We have two cases. The first one is Johnson and Harrison versus VanderKooi and the City of Grand Rapids. This is a 20-minute argument per side. Mr. Korobkin, you may attempt to reserve some of that, but we're going to ask you to try and keep track of that yourself, and you may begin.
Very good. Thank you. Well, good afternoon, and may it please the court. I'm Dan Korobkin from the ACLU of Michigan, representing the plaintiffs, and I will try to reserve 5 minutes for rebuttal. Taking fingerprints during a Terry stop violates the Fourth Amendment. And there is a straightforward two-step path for this court to follow to reach that holding. Step number one, the fingerprinting was a search under the trespass-based approach to the Fourth Amendment because the police physically intruded on the plaintiff's bodies to obtain information. And step number two, the search was unreasonable because it was conducted without a warrant and no exception to the warrant requirement applies. Now, as you know from our briefs, there are alternative paths the court could take to reach the same conclusion, namely that a search occurred under the reasonable expectation of privacy doctrine, and that irrespective of whether it's a search, it exceeds the scope of a permissible seizure under Terry versus Ohio. But I will set those alternative arguments to the side for now, and at this point say a little bit more about our primary arguments. Starting with the question of fingerprinting being a search. In United States versus Jones, the Supreme Court held that a physical trespass to a constitutionally protected area for the purpose of obtaining information is a search under the Fourth Amendment. And when this court applied that rule in People versus Frederick, you noted that because police officers there strayed beyond what any private citizen may do, they were committing a trespass. And then significantly in Grady versus North Carolina, the Supreme Court held that this physical trespass doctrine was not limited to homes or personal property. It applied to physical contact with the human body as well. So that series of holdings leads inexorably to the conclusion that applying ink to someone's fingers, physically manipulating their hands and pressing their digits onto a fingerprint card is a search under the Fourth Amendment. It's a physical intrusion on a person's body. It obviously strays beyond what a private citizen may do because at common law, this would be a battery. And it's done for the purpose of obtaining information. So that brings us to step two, is the search unreasonable under the Fourth Amendment? And again, the answer to that question is straightforward because the Supreme Court has held time and again that when law enforcement conducts a search without a warrant, the search is unreasonable per se unless a specifically established and well-delineated exception to the warrant requirement applies. Now, in this case, the city has not even identified an exception. And in the 50 years since Terry versus Ohio was decided, the Supreme Court has repeatedly admonished that the only permissible search during a Terry stop is a pat-down check for weapons. So obviously, fingerprinting is not a search for weapons. It's therefore an unreasonable search in violation of the Fourth Amendment. With that, I'd be happy to answer any questions.
Thank you, Mr. Korobkin. I'll start with Justice Cavanagh.
I don't have any questions at this point.
Justice Welch.
I just have a quick question. Thank you so much. I am wondering, so in Johnson's case, I believe I have my parties correct, the police were investigating a series of break-ins in the parking lot at issue. And so I'm wondering, what your perspective is on what valid action they could take based on that information.
Yeah, I think the Terry doctrine makes it clear that a brief stop for questioning based on reasonable suspicion is allowed. We're not really contesting reasonable suspicion in this case to make the initial stop. I think it could be contested. That's not the focus of this case. But there is a dividing line once that stop occurs in terms of what can happen after that. Our position is that even if this isn't a search, you can't go beyond that and require fingerprinting. But certainly the courts have been very clear that you cannot conduct a search during a Terry stop, except a pat down for weapons. And so because fingerprinting is a search under the trespass doctrine, the police were restricted in what they could do, and they could not conduct the search that they conducted here.
Thank you.
Justice Zara.
No questions. Thank you.
Justice Viviano.
Yes, thank you, counsel. My question is, you're asking for, first of all, you're making a facial claim, is that right?
We've made both a facial claim and an as-applied claim. I think the straightforward path for the court is to address the facial claim as a Fourth Amendment search and hold that practice unconstitutional.
Under the trespass theory, what if the fingerprints can be taken without a physical intrusion? Would that be an impediment to your theory? In other words, it appears that law enforcement now in places around the world, maybe around the country, are able to take fingerprints off a photograph. Of course, photographs can be taken without a physical intrusion. So I'm a little concerned that if we were to agree with you, you stated your rule at the very beginning that taking fingerprints during a Terry stop violates the Fourth Amendment, that type of sweeping holding would not account for new technologies that might allow that to be done without a trespass.
Right. So Justice Viviano, I think you're right that if this case were a factually different one where there was no physical touching of the plaintiffs, there was no sort of common law battery, as it were, we would be outside of the physical trespass doctrine and back into the reasonable expectations of privacy doctrine. And there too, I think it's also clear that although we walk around in public. And, as the city mentioned, our hands are exposed to the public. There is not an expectation that the police will be able to take from your, through casual observations, the information that would be needed to get a fingerprint. And so I think we would be going to the Kylo case around, advances in technology and the need to make sure that the protections of Fourth Amendment rights are preserved at the stage that they would have been during the founding, as well as the fact that we've had cases in addition to Kylo, such as Bond versus United States and Florida versus Riley, is it Riley? Which really demonstrate that what's important is what kind of information could the public get from casual observation and without using technology that's not available through public use. And I think all of that would lead to the same conclusion, just through a different path, through the reasonable expectation of privacy path, as opposed to the physical trespass path.
But of course, if we're to write an opinion, it'd be hard to write the one you just described, right? Where we start on the one path, but then account for the other path as well. So I guess my question is, would it be a more precise statement of your theory or your request for relief that you believe taking fingerprints by conventional means during a Terry stop violates the Fourth Amendment?
I think we would argue that under both doctrines we would win, and the court, if it's concerned about making sure that the holding is relevant not just to the physical the physical manipulation of fingers, but also to a photograph, that it could use both analyses to do the analysis. In this case, it was a physical trespass. And so I think all that's needed for the plaintiffs to win their Fourth Amendment claim in this Section 1983 case is a ruling on the physical trespass component. But you're right that if the if the need is to address future developments in technology or in the practices that police use, the Supreme Court has done that a lot and made holdings that anticipate those developments as well.
Yeah, the problem is, of course, if it's a facial claim, then we have to think about these questions, which are whether there are any circumstances in which the policy can be applied in a constitutional manner. And I think, I guess, it's a very much of an open question, I would think, whether, a photograph, we allow photographs to be taken of suspects, and this policy itself deals with photographs taken of suspects. And whether the sort of on the back end, whether it's facial recognition software or this ability to, if you take a photograph of somebody's hands, to analyze them for fingerprints, whether that somehow violates someone's reasonable expectation of privacy. I mean, it just doesn't seem to be something that was at the center of this case, but I started thinking about it because I'm trying to figure out whether this could be a facial constitutional violation. So anyways, thank you, counsel. That's all I have.
Right. If I could just to point out, I think the record reflects that the policy was to take physical fingerprints, and that's what the facial challenge is challenging, is the actual policy and practice of the police department. So I think we could still maintain the facial challenge, but I understand the point about, other departments might do it differently.
Right. Yeah, that's why I asked you the question about, are we focusing on conventional means? And if so, I think you have sort of a cleaner theory. But anyway, thank you, counsel.
Justice Bernstein?
So good morning. I have a question kind of from a more pragmatic position, because I remember I had the opportunity to write the opinion on this case, a short time ago. It kind of folds into this one. But the question I have, and I remember there was kind of a little back and forth on it, what has happened to the fingerprints? Where are the fingerprints, and what is the status of the fingerprints?
My understanding, Justice Bernstein, is the record reflects that the fingerprints are stored indefinitely in the police department's database or files. And the complaint in this case, it goes back about 9 years ago, but the complaints in this case do request, as part of the relief, that those fingerprints be destroyed.
And I'll ask this, and I realize that this might not be in your purview, but I'm going to ask the same question of them too, is ultimately it's kept on file with the police and can be processed or used at any time?
Yeah, I mean, my understanding from the way fingerprints operate these days is under the AFIS system, tens of thousands of fingerprint comparison searches can be run through computerized means per second to sort of match up a fingerprint on file with any in the entire country. So my understanding is that would be available to the city once they get this information.
Counsel, thank you very much.
Justice Clement?
No questions. Thank you.
I believe Justice Cavanagh now has a question.
I do. Thank you. I'm just wondering if you could, is this question of whether it's a facial challenge or an as-applied challenge, is that really relevant to your client, the plaintiff's claim of entity liability under a 1983 action? I'm struggling to see what the relevance is of that sort of intellectual exercise.
Yeah, Justice Cavanagh, I think that's right. I don't think it ultimately makes a difference because under the Monell doctrine, as long as there's a constitutional violation and a policy was a moving force behind that constitutional violation, the municipality is liable. And one of the reasons why these facial and as-applied labels can sometimes be confusing is because it kind of depends how you define or split up the policy and practice, right? So if the city says, all right, our policy is police officers can do A or B, and the police officers do A, is the policy is really two different policies. It's the police could do A, and another policy is the police could do B. And you could divide up whether A is unconstitutional as B is unconstitutional and make your facial determination that way. So I think regardless of where we're at in terms of facial as applied, the police violated the Fourth Amendment rights of the plaintiffs in this case. The policy was a moving force behind that violation, and therefore the city is liable under the Fourth Amendment in our case.
So holding by this court saying that there is a Fourth Amendment violation still leaves you to the task of establishing entity liability under 1983.
Well, Justice Cavanagh, I think we did that in round one of the case, and when we brought it to this court 2 years ago, I think that's what was essentially established. And so I think at this point, there's not a dispute materially about the facts in terms of whether the Grand Rapids Police Department had this policy. And I don't think there's really a dispute about the fact that the policy was the moving force behind what happened to the plaintiffs in this particular case. And so I think at that point, it's really a done deal in terms of both the Fourth Amendment liability and the municipal liability.
This is the final piece sort of the Monell claim.
This is the final piece.
Thank you.
Thank you, Mr. Korobkin. You may reserve or you may keep talking.
No, I'll gladly reserve the rest of my time. Thank you very much.
Thank you very much. Ms. Fossel, you may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. It's a privilege to be here. My name is Elizabeth Fossel, and I have the honor to represent the city of Grand Rapids in this matter. There are 3 points that I hope I get to make to the court. I know we'll probably spend a lot of time asking questions, and I hope answering them to your satisfaction. But I do want to point out there are 3 things that I think are important. It's probably unusual for me to start here. The 3 points that I would make is that Michigan law currently holds that taking fingerprints does not violate the Fourth Amendment because there is no reasonable expectation of privacy in one's fingerprints. Michigan law is consistent with federal precedent on this particular issue. And third, Michigan law and the PNP policy in particular are consistent with the U.S. Supreme Court's guidance on taking fingerprints in the field. But I feel that given where the appellants have started their argument with the trespass issue, I should probably address that first. As the court knows, we have taken the position that the trespass issue was not preserved for argument before this court. Indeed, it was not raised at the trial court level or even in the first rounds of the Court of Appeals. It was raised years on when it should have been involved at a much lower level, and we believe it has been waived at this point. That being said, I recognize that the court can decide this on the trespass basis if it wishes to, because this court has the power to take up unpreserved issues. However, from a substantive, so let's put the procedural away and look at it from a substantive standpoint. On the trespass issue, really, appellants fare no better. Their theory of trespass is essentially that any unconsented to touching combined with information gathering equals a search. If that's carried to its logical conclusion, then their theory leads to absurd results. No officer could go hands-on to detain a suspect when initiating a valid stop, even when his sole purpose is to conduct the very investigation that Terry authorizes. No officer could continue a legitimate stop by physically hindering a person by touch or telling him to stay put until a lien search was completed. No officer during an investigation of crime could escort an individual or put him in a cruiser, even for that person's own well-being, and then turn around and ask a few questions related to the person's name or address or their connection to the events that led to the stop. And logically, an officer couldn't even knock on a car window in the course of the stop to get a driver's attention in order to ask any questions. That cannot be the law in general and has never been the law in the case of fingerprints. In fact, the appellants have cited no cases in which trespass has been applied to fingerprinting whatsoever.
Counselor, let me interrupt you and we'll get through questions, and then if you have more time, you can continue, but I'll start with Justice Cavanagh.
No questions.
Justice Welch.
Thank you, and thank you, Ms. Fossel. I do have a question. I want to just sort of jump to what is a third issue in this case about the notion of a Terry stop and how long it can last. I admit I'm struggling with the facts of these cases and how much an officer has to do to investigate under the Terry parameters, and having that extend to fingerprinting being a necessary part of that. And I'm wondering if you can help me out with your thoughts on how that's valid.
Yeah, I think the answer to that, Justice Welch, lies in the case of Hayes versus Florida, which was derived from Terry. Hayes versus Florida basically took the position that there was support in the case law for a fingerprinting in the field as part of a Terry stop. When first of all, there had to be reasonable suspicion for the stop. We have that here. Nobody's disputing that. There had to be a reasonable basis for the officer to believe that fingerprinting would establish the connection or dispel the connection of the suspect to the crime. And the process had to be done with dispatch. How much dispatch is always going to be, I suppose, something that can be discussed. But the real key here is Hayes set up an objective test to determine whether the scope of the Terry stop is exceeded and whether or not it's going to take too much time. In other words, it's not being done by dispatch. That kind of a test, essentially a reasonableness test, is always going to be dependent on facts and circumstances. And in this particular instance, I would suggest that if the detention for purposes of the stop has a justification of the prints, of taking the prints as part of the stop, then Terry's scope in both, Terry's requirements in both terms of both scope and duration are satisfied.
Okay, so then looking at the facts of this case, in the case of Harrison, who I believe was in the park with the train, why were the fingerprints necessary?
Mr. Harrison was stopped, you're right, because he was involved in a transaction with another person where he handed property off to that individual. The officer at the time thought that looks like it might be a valuable collectible, and I'm going to investigate further. He then drives around the park and loses sight of the individual who has taken the train away from the site, right? Mr. Harrison at that point is now kneeling or crouching in the park, ostensibly because he says he's helping birds. And Officer VanderKooi determines that he's got to investigate this further. We're in a neighborhood that has a high incidence of break-ins and thefts during the day after school. And VanderKooi is aware of that based on his 30 years of experience in Grand Rapids and knowledge of the neighborhoods. So he stops Mr. Harrison, who agrees to talk to him at that point. And he inquires what he's doing. Mr. Harrison gives the explanation about the birds, which frankly made no sense to VanderKooi. There were no birds in the park. He didn't see them anywhere. And he was concerned that what Harrison had actually been doing was serving as a lookout in that particular high break-in neighborhood. So when Mr. Harrison has no identification on him, Mr. VanderKooi has a couple of alternatives. Under the appellant's theory, he should have just let the fellow go, bought the story about his name, and let him go on his merry way. But the problem is that there's a need for accurate identification in any criminal investigation for a number of reasons, not the least of which is to make sure the person's name is what they say it is, because if they are later let go and they've lied about that, how are you going to track them? Secondly, if the individual is involved in the theft of some valuable collectible or serving as a lookout for other break-ins in the property, his fingerprints may very well tie him to those crimes that are under investigation. So we therefore meet the second part of the Hayes test, a reasonable basis for believing that the fingerprints will connect the individual or dispel the connection of the individual to the crime that's under investigation. It's done in a matter of minutes, and the individual is allowed to leave when Officer VanderKooi has it confirmed that the individual had given what is described as a truck or a train to another individual, and that individual is found and confirms Mr. Harrison's story. There is no extension beyond the reasonable duration of the Terry stop, and the fingerprints were taken on a reasonable basis, under a reasonable basis to believe that they would connect him to a crime.
Okay, thank you.
Justice Zara.
No questions.
Justice Viviano.
No questions at this time. Thank you, counsel.
Justice Bernstein.
Counsel, good morning. Thank you for coming. I have a few questions that I just want to kind of run through with you on this, if that's okay. The first one is, going through, and I think you did an excellent job, but kind of going through your description of the facts and play out this a little. In this situation, basically, what ultimately will now happen in this is just kind of as you've kind of explained everything that kind of, occurred in terms of those interactions. This young man is now going to have his fingerprints in a database, and that will exist forever. And do you see how that will be somewhat concerning? It's not like it's a one and done situation. All those fingerprints are going to live within a database forever.
Your Honor, it's not clear to me that they are going to live in a database forever. They certainly are not going to be part of APHIS. They have not been uploaded to APHIS, which would be the national database for fingerprints. They are currently in a box in the Grand Rapids Police Department where they have been since the beginning of this case, and they've been preserved for purposes of this case. I think at the conclusion of this case, if either the court orders the destruction of the fingerprints, or if appellants make a request that they be destroyed under the statute that currently governs biometric information, they can be.
Okay, so would the city then stipulate, let's say, in terms of the outcome of this case, whether the policy is allowed to continue or not, would the city stipulate that the fingerprints will be destroyed no matter what?
Provided that neither, I should say, in the case of Mr. Johnson, I believe those thefts are still under investigation, and I can't represent to this court that they would be destroyed under those circumstances. But to the extent that neither of these individuals have been charged with the crime that was under investigation, I would think there would be a reason to request that they be destroyed.
Okay. What about the other people that have been part of this process? What will happen to those fingerprints?
Your Honor, it would depend on whether or not they were charged with the crime. If they're charged with the crime, it is going to stay
If they're not charged, I'm talking about folks that have not been charged. What's the disposition of the fingerprints?
I can't tell you that, Your Honor. I don't know. I think that is a matter that we could take up outside the context of this case, because if there is no use for the fingerprints, then I would understand the appellants and their counsel's concern over maintaining them.
Sure. And just, looking at things kind of I like to look at things from a very, again, simplistic, sometimes kind of more common sense kind of approach is how I like to kind of look at things in terms of how it affects people in ordinary life. And you use some examples in your argument where you had indicated that, that if the court were to hold this to be unconstitutional, that, that an officer wouldn't be able to knock on the window of the vehicle. And I guess my question is that, looking at this from just, in a common sense perspective, can you appreciate the perspective that arises out of this situation when, it's one thing to be asked for ID, and many young people don't have IDs, but let's just say it's another thing to have a conversation. It's one thing to have someone tap on your window. There's a little bit of a different feeling that comes out of this when you have to present your hand and your fingerprints are taken. I mean, do you see that does kind of create that level of discomfort? And often is the case, I'm just thinking of it from my perspective, if I was having my fingerprints taken on a city street, I would feel somewhat humiliated.
Your Honor, I appreciate your question, and I do understand it. I think I need to clarify what the policy actually allows. Fingerprinting can be taken only under two circumstances. First, when the officer is in the course of writing a citation or an appearance ticket and the individual has no idea, in which case, of course, probable cause already exists. Second, which is the case here, when the officer is in the course of a field investigation and the facts and circumstances of the investigation itself render fingerprinting appropriate. In other words, it's not done on a carte blanche basis. It's not simply done because you have no ID. We go back to Hayes. There has to be a reasonable basis for taking fingerprints in the field in order to be within the confines of the policy that existed at the time. So this is not a carte blanche, you get fingerprinted, you know, if you have no ID and I stop to talk to you. That's not going to happen. There has to be a connection to the investigation, and that's what occurred here. I don't dispute that it's a little awkward to be out in the field and having an individual fingerprinted in the field, but it's also awkward to be in the field and talking to a police officer. It's also awkward in the field to be stopped at all. This is not something that I would say we don't take account of, but I would say this is why we have a reasonableness requirement before we ever take a print in the field.
Oh, I understand. But again, that's still somewhat subjective, right? I mean, you know, there is that subjectivity in terms of, you know, it leaves a tremendous net that allows for an enhanced subjectivity as to, you know, as to the ability for folks to be fingerprinted, but which is where my concern lies.
And I appreciate Your Honor. I do respectfully disagree. I think that the Hayes test eliminates the subjective nature of this and requires an objective assessment of whether or not the fingerprints are going to connect or dispel the connection with a crime.
Counsel, thank you very much.
Thank you.
Justice Clement?
No questions, thank you.
Counsel, I think maybe I'm asking a question Justice Welch answered, and maybe I just didn't appreciate your answer, but explain to me why once the officers determined that Harrison hadn't stolen was it a toy train or the toy, and Johnson had not been breaking into cars, why again is fingerprinting important at that point? Like, why isn't it reasonable for that to be the end of a Terry stop? Why would fingerprinting in any way be related to the reasons for the stop, which I think is what Terry requires?
I appreciate that. The answer is that there was not a determination that Mr. Harrison hadn't stolen the property, or that Mr. Johnson was not involved in the break-ins in the car. What was determined was there was no probable cause to arrest them at that time. In Harrison's case, his story checked out with the later interview that was done with the individual who took the property on the bike. And it was at that point that VanderKooi said, I have no probable cause to arrest him at this point. The fingerprints have already been taken. In the case of Mr. Johnson, that was an open investigation, and the fingerprints needed to be taken to compare with the latent prints in the other cases. Now, there was no probable cause to arrest Mr. Johnson under the circumstances that existed at that moment, but there was reasonable suspicion for believing that he was involved. After all, he'd been identified as acting suspiciously and looking into cars at the time on that very day. But there was no probable cause. That's different from saying, I've determined he's not involved in something.
But my understanding is that any continued trespass would have to be related to the investigation. So the fingerprinting, I guess you're saying in the case of Johnson, was related because you were still going to be looking for connections to prints on other vehicles. I understand that. Right. But in the case of Harrison, your answer was that fingerprinting had already happened before we confirmed that his story checked out, but we still kept him? Like, why do we keep him? Just because later on down the road, it'll make it a little bit faster if we arrest him again? Like, what's the
Keep in mind, I'm sorry, Your Honor.
No, go ahead.
Keep in mind that in Mr. Harrison's case, all right, the property had disappeared. The young man took the property from Harrison, biked off into the distance. By the time the officers find the young man who had biked off into the distance, he no longer had the property. If that property was stolen, then a crime had been committed. But at that point, with the property gone, with the stories being corroborated, there was no probable cause to arrest Mr. Harrison. That doesn't mean the investigation is over at that point. There still may be stolen property. If it's recovered and it's stolen, the fingerprints may very well connect them up to it.
Because they both might have lied in exactly the same way and gotten it right.
I'm sorry, you mean the boys, the
Yeah.
two young men?
Yeah.
Yes, they could have lied in the same way. If this happens to be a situation where there are a number of people involved in thefts in that neighborhood and that had a high break-in rate, remember, there could have been an understanding of what we say when we get stopped by the police.
I see. Okay. You have 24 seconds.
Well, Your Honors, I want to just I'm going to do this really quickly. I'm going to stick with the trespass issue because I do not think this is appropriate to decide the basis for the decision of the court. The trespass cases that have been cited all involve either a literal trespass onto someone's real property or attaching tracking devices to an individual to monitor movement over time. That's also true in the Grady case, in which the appellants so heavily rely. That was a tracking device attached to a recidivist sex offender for the rest of his life to monitor his movements. That's not the case here. No one had anything attached to their body in terms of a device. The fingerprints were not taken to track movements. And in fact, Mr. Harrison consented to the fingerprinting. And with that, I see my time has elapsed. I thank you for your time.
Thank you, Ms. Fossel. Mr. Korobkin, you have about 4.5 minutes.
Thank you. A few points to respond here. One, just quickly on whether we preserved the issue. We raised this in briefing before the Court of Appeals. There was no objection to us raising that in the Court of Appeals. No objection was set forth by the city. And then the Court of Appeals decided the issue on the merits. So we think that's enough to preserve the issue for this court to review. I would just add also that we shouldn't be conflating different claims with different arguments in support of the same claim, right? So it's always been a Fourth Amendment unreasonable search and seizure claim about the fingerprinting. The fact is that the Jones argument is a different argument from the reasonable expectation of privacy argument. But the Supreme Court has said, look, if you're bringing, and this is in the Yee versus Escondido case, look, if you're bringing a Fifth Amendment takings claim, you can choose different arguments in support of that claim over time. The point is that if you brought the claim from the beginning, you've preserved it. On the trespass sort of parade of horribles situation involving touching the police officers knocking on the window or touching the suspect, that's not the case. Those don't implicate the trespass rule because, as this court recognized in Frederick, trespass has to be both the physical trespass and doing it to obtain information. And so stopping someone who's walking down the street to effect the stop, that's a seizure under the Fourth Amendment, but it's not a search to obtain information. Also on the Hayes point, we addressed this in the brief, but there's no dispute that the Hayes sentence that they're quoting from is dicta. And then I think, that was 1985 and subsequent holdings have really eviscerated that point as a real holding as a real rule under the Fourth Amendment. Obviously, Jones sort of changed everything when it comes to the physical trespass rule. But even Bond versus United States and Florida versus Riley all came after Hayes and made clear that your reasonable expectations of privacy are going to be violated if the police are going to be able to obtain information in a way that the casual observer would not be able to do that. And there's no question that fingerprinting something is not something that that a casual observer walking down the street can do to you, or that you would have a reasonable expectation that they would do to you. And then under reasonableness, the Supreme Court has doubled down on the point that if there's a warrantless search and no exception to the warrant requirement applies, the search is unreasonable per se. And so the Hayes dicta just doesn't square with that very firm rule. There comes a point, Your Honors, during a Terry stop when the invasiveness of that stop, whether it's a search or whether it's not a search, goes too far in comparison to the privacy interests of the individual. And that's what happens when fingerprinting is involved. Fingerprinting, we know, is something that happens as part of the booking process after you're arrested. That's what you expect. And to move that into the on the side of the road type of interaction between the police and individuals on the street fundamentally alters the nature of the stop itself. And in Hibble, the Supreme Court was very clear, although you could request and even require someone to provide them with information about who you are, they did not. They said that we're drawing the line here because because going further would fundamentally alter the nature of the stop itself. Our position, of course, is that the fingerprinting during a Terry stop, which, as far as I know, is relatively unheard of in Michigan and perhaps throughout the country, fundamentally does that, and that's why it's unreasonable either under the search doctrine or as impermissible under Terry versus Ohio. So for that reason, we'd ask the court to reverse both the judgment of the Circuit Court and the Court of Appeals.
Thank you. Thank you both. The case will be submitted.